Closing argument.
Thank you very much. Now, may I leave the setup? Put that in here.
Yes, sir.
May it please the court, Madam Clerk, Court Security, opposing counsel, Mr. and Mrs. Long. Ladies and gentlemen of the jury, first, thank you again. I know both sides of this case. We've looked over the course of this trial and noticed how much y'all have paid attention. And the parties can't thank you, and the lawyers can't thank you enough for being so interested in this issue for us. We know it's not your job, you're not getting paid to do this, and we feel we're in awe of the duty that you've showed us with your attention. Thank you very much. Common sense versus coincidence. That's what this case boils down to. And you're going to have a lot of decisions to make as a jury deliberating in this case. And the reason I say that is, you're going to have to decide not only the liability, who's at fault, but you're also going to have to decide what are the damages and what was caused by this wreck, if anything. And I think the phrase common sense versus coincidence is going to come in handy when you're doing those discussions back in the jury room. And the way our system is set up, as I explained to you in jury selection, is that you're going to be around the table basically discussing these various issues. And one juror may say, I don't think I heard this, enough of this, and I think this about this subject, and there's going to be back and forth, right? And the judge has instructed you that it's your collective memory of what was said basically in court that you're going to use for testimony. And then you're going to have these exhibits over here. And whether you're looking at the defense exhibits that are all numbered and labeled, or the plaintiff's exhibits that are all numbered and labeled, you're going to have these with you to discuss the case. But you're not going to discuss the case as a whole generally. You generally discuss issues. Because usually people are like, well, what about this? And so the purpose of closing argument is for me to talk to you about those issues that are likely going to come up in your deliberations. And I think the best way to do that, maybe it's the Boy Scout in me, I think the best way to do that is to use a map. And the map that I think everybody thinks about is the verdict form. So let's put it up. The judge just referenced it. There's going to be one back there with you guys. And, of course, it's titled verdict form. And let's blow up to question number 1. So I said earlier that liability is an issue, right? That's the who's at fault part of the case, right? And question number 1 is, was there negligence? Now, what is negligence? The judge just told you what the word negligence is. It's reasonable care, what the reasonable person would do under similar circumstances. Okay? Now, what evidence do we have in this case that Ms. Long, who was Ms. Sparks at the time, was negligent? Now, y'all, negligence is not like some horrible thing. Okay, we all are negligent on occasion. We all are probably negligent every day, but it's rare that negligence causes injury to another person. right? We can be negligent in our own bathroom, right? And there is no consequence to others, right? And negligence, though, can also be rolling through a stop sign, right? Or pulling through, or running, not running, but going through a stop sign when you should be a little better about what's going on, and then you inadvertently collide with somebody. That doesn't make you a horrible person. You just made a mistake. So what evidence is there that there was negligence on the part of Miss Long? Well, let's look at the scene. When you look at the pictures of the scene, we've seen the overhead picture, right? And what about the overhead picture helps us? We all know Woodbine Road. You don't have to even live near Woodbine Road to know that Woodbine Road is a major thoroughfare in Santa Rosa County. You also don't have to be an expert on traffic patterns in Santa Rosa County to know that in the mornings, between 7 and 9 o'clock on a work day, Woodbine Road is not going to be the easiest place to navigate. The evidence in this case is that traffic was backed up on both sides of that road. So let's look and see what that means. What that means is that there is traffic that is all the way in here, whether it's a school bus or a white car, everything's backed up to the spot where the driveway starts, going into this Drowsy Poet or Coffee Break Cafe, right? And then what happens on this side? Well, there's traffic here too. There's just enough room for somebody to get out. If there's traffic here and traffic here, then what happens to your view if you're here? If there's traffic here, what happens to your view of this? It becomes a problem, right? It's not ideal. It's not an ideal situation. And turning left out of this becomes a little bit sketchy at the very least. Because now you're basically relying on others around you to navigate yourself out of there. And that's never an easy thing to do. So we've got a situation already where somebody is at a stop sign and everybody else has the right of way when you're at a stop sign, right? And you've got a situation with traffic. So you're raising the odds that something bad could happen if you're not being very, very, very careful. And there's no question, looking at this picture, that Miss Long absolutely had a stop sign. Right? This is the common sense part of this equation. Who had the stop sign? Right? So we got a stop sign, but it's not just a stop sign. It's a stop sign under the conditions of Woodbine Road at that time of the morning with that kind of traffic. It requires inching out if you're going to do this kind of thing, right? So, the common sense part of this is who had the right of way. Miss Williams had the right of way, okay? And now this idea that you can basically bend the inside of a door frame by basically rubbing up against another car. So let's look at the damage pictures again. I just want to look at one of the damage pictures because I really think it's important to look at it. You remember the door got dented, okay, pretty bad. But that does not come from a force that is rubbing along the front of a car. You can see that, as you can see from the picture itself, there's a focal point. It almost makes an X. And the picture. And then when you go to the picture of the inside of the door, you get an idea of what kind of force was involved and which direction it was going. So let's look at the inside of the door jamb picture. Now, if this was some kind of side swipe type of rub against Miss Long's car without any force coming from the truck's direction, the penetration into this would be hard to see how it would get there. And then the testimony is that Miss Williams's car actually spun to some degree afterwards. So we're not dealing with a small amount of force if somebody's inching out. Imagine you inching your car out, looking both ways, right? All right, I got all this traffic, somebody's waving me on or not, and I want to make sure I'm being very careful, right? Versus the person that just, let me jump out there real quick and just get this done. Somebody's waving me on here, I don't look back the other way, and I just jump out. Have we all done that? Probably so. Have we all done it? Probably so. Have we all ended up hitting somebody? Most of us haven't, thankfully, right? But it happened this day. So when it comes to the first question on liability, what's the common sense approach to this? Somebody had a stop sign, somebody didn't. There was a decent amount of damage to the car, and the traffic conditions were such that anybody trying to turn left out of that parking lot would have to be very, very, very careful to be reasonable. They just would. Doesn't make her a bad person, but the answer to that first question has to be yes. Now, in regards to Miss Williams' negligence, they claim that Miss Williams is negligent. And then the basis for that claim, I think, is just one thing that I can tell. The basis for that claim is immediately after the wreck, she said something like, I shouldn't have been driving because I was up late with my sick daughter, and I should have never been driving. Okay, so let's just take that evidence for a second. And let's say she said, I should have been driving because I was completely drunk. Does that make her at fault? If she's got the right of way? The answer is no. If you have the right of way, it doesn't matter if your daughter was sick that night. It doesn't matter if you didn't sleep for 3 nights. It doesn't matter if you were drunk. You're going to get arrested for DUI, but you're not going to be at fault for the wreck because you didn't do anything wrong. You had the right of way. That's why we have these traffic rules. That's why they're there. You're certainly going to go to jail, and rightfully so if you're drunk, right? But it doesn't make you at fault for the wreck. And even if you accept their answer, their theory that she got out of the car and said she was up all night with a sick child, which when you drop somebody off at daycare, it's hard to believe that you would stay up all night with a sick child. But if that is what you believe happened, that still doesn't move the needle on liability because Miss Williams still had the right of way. I think, from a common sense perspective, that's how this should be thought of, right? But there could be someone on the jury that thinks, well, wait a minute, what if Miss Sparks, Miss Long, was sitting at the stop sign completely still behind the stop sign, completely still. And then I don't think the testimony has come out like this, but let's say that was somebody's interpretation. And Miss Williams drove her car basically into Miss Long. Will the damage be different if that happened? I think so. Because you've got damage to the rear car, the rear door, not the front, right? If you were to drive your car into somebody, you would be driving the front of it into somebody. There has to be movement of Miss Long's car for there to be only penetration on the back door. The wreck would look entirely different if Miss Williams cut that corner short or cut the turn real sharp and ran into Miss Long. We'd have a different looking wreck. That's not what happened. I'm not going to spend a ton of time on this because I don't think that you guys are either. I don't want to be presumptuous of that, but this is not a complicated wreck scene. So the answer to the question, was Miss Williams negligent? No. And so when you mark note of that, you don't even go to the section that deals with percentage of fault, right? You don't go there. You don't have to. All right. So now let's talk about what I think is going to occupy most of your time, and that's the injury, because this is complex. I think every doctor that testified in this case said something to the effect of, this is a complex kind of situation. I mean, brain injuries. Think about it for a second. We're not dealing with a knee or a back or a neck. I mean, this is the brain is a complex organ. Dr. Eastfold used this model, and you'll remember that she went over the lobes of the brain. This is a demonstrative aid, so it won't be in the jury room, but I'm going to use it to talk to you all about it. But she said that there's a frontal lobe and then a temporal lobe sort of on the sides in the front. Temple, I guess everybody knows where their temple is, right? Because you're taught as a kid is be careful with your temples. So the temporal lobe and the frontal lobe is where this part of the brain is, right? And I think it's clear from the testimony that Ms. Williams says that she struck the left side of her temporal frontal lobe. That becomes an important fact. And I think it's important to point out that there are two distinct injury claims in this case. And I'm going to go through them in detail and talk about the witnesses that support each one. The first injury claim, and I think the more significant one, at least from my standpoint, is this wreck has caused permanent seizures. So I want to talk about that one first. But I also want to mention the second. The second injury claim in this case is that this wreck has caused cognitive thinking problems. Those are two distinct claims. The reason they're distinct is you can have them and not have the other. So you can have cognitive problems and not have seizures. You can have seizures and not have cognitive problems. Although most every doctor says in the long run, if you have seizures, you're going to end up with cognitive problems. I think all the experts said that. So when you're back there discussing the injury part of this case, it's important to remember there's two distinct injuries. There is a seizure injury, which is devastating. There is a cognitive injury issue, which is also devastating, but they're two distinct injuries. And the experts that came in were very specialized. You'll remember this. Dr. Herkoff and Dr. Eastfold were cognitive experts, neuropsychologists. They only spoke to the cognitive injury part of this. The neurologists, Dr. Greenberg and Dr. Baer, those gentlemen spoke to the seizures issue, and they spoke to the cause of the cognitive problem because they're medical doctors. So they did double work. They were working on both injuries. The neurologists were testifying on both injuries. They were talking about, I think this is related or not related, i.e. the seizures. I think this is related, not related, i.e. the cognitive injury. So the neurologist, Dr. Greenberg, and Dr. Baer spoke to the cause of both the seizure issue and the cognitive issues. So when y'all are back there discussing that, the two injury claims, even though they're distinct, they share a common witness, the neurologist. But they don't share the Eastfold and the Herkoff. Those witnesses only were speaking to the cognitive issues. Okay? So let's talk about the proof. Because the next question you have to answer, if you don't go any further, if you don't get past the next question, the next question you have to answer is, did Jessica Williams suffer a permanent injury within a reasonable degree of medical probability? This is also a good time for me, and I probably should have done this sooner, to talk to you all again about the burden of proof. We talked about it in jury selection. And I think you'll remember I said, it's not a criminal case, beyond a reasonable doubt, it's more likely than not, or greater weight of the evidence, right? And that's just greater than 50%. So, some people, we went through that jury selection. All of you accepted the fact that, it's a lesser burden in a civil case because we're dealing with not somebody's life and liberty, we're dealing with money damages. And so we talked about how everybody here has agreed that the more like a greater weight of the evidence standard is fine. But what is that? We make these decisions all day long. You as a human being have made more likely than not decisions since the minute you woke up. Whether it's what route to take, whether to change lanes, whether you need to use your blinker to change a lane, whether you need to set the oven early or coffee maker at a certain time, whether you need to use 2 scoops of sugar or 1, whether to get the right combination. You do more likely than not decisions all day long, every day. This is not a complex, esoteric thing. More likely than not is, what's more likely than not? Greater weight of the evidence. Your common sense, Your Honor has already told you in jury instructions, can be used to help you guide yourself on the more likely than not standard. But the next question you have to answer is, did Jessica Williams suffer a permanent injury within a reasonable degree of medical probability? Okay? So what evidence did we offer that shows she has a permanent injury? Dr. Baer has testified as the treating neurologist, right? Now, what is a treating neurologist? A treating neurologist is the doctor that you get because that's where you're sent. And you're treated. We all have. We all have treating doctors. Dr. Baer is Miss Williams' doctor. He's not a paid expert. And Dr. Baer has treated Miss Williams since 6 days after this wreck to present day. So that's nearly 5 years. 5 years. He's not getting paid $10,000 a day. For 5 years, he and his PA have treated Miss Williams for this wreck. They've run tests. They've checked her in the office. They've done neurological exams on her. They've conversed with her more than any other doctor has. And he has testified, in this case, that in his opinion, to reasonable medical probability, that she has a permanent seizure disorder. Now, why does common sense make you believe that that is accurate, that that is reliable? Other than what I've already said. He's a treating doctor. He's not a paid expert. He's been treating her for 5 years. He's seen her since the very beginning of this. I'm going to give you one thing that should be, when this discussion happens, It's irrefutable. I mean, it's just something you cannot deny. And the defense expert's been denied it. It's 3 letters. E, E, G. It's basically an X-ray of your brain. And since the brain, like the heart, has a lot of electricity in it, it captures things that are abnormal. So if you were to have an EKG, it would capture abnormal electrical activity in your heart. But an EEG has the electrodes on your head, and it's looking for abnormal seizure-causing electrical activity in your brain. Normal people, as Dr. Baer said, don't have seizure activity, electrical activity in their brain. So, you're going to have this exhibit. It's in both the defendants and the plaintiffs. You can see the number at the bottom. This is Plaintiff's Exhibit 6. You can scroll down to 63. So if there's a discussion back there, how do we know she really has seizures? Let's say one of the jurors is like, I'm not convinced she's got seizures. That could be a topic, right? It should be a topic. I don't believe she has seizures. Okay? Well, why is this important? Well, it's objective evidence. In other words, it doesn't matter what you say. It doesn't matter how you feel. It doesn't matter if you think I'm having seizures. You can't create this activity in your brain. It's objective. It's so objective that every treatment that's been prescribed for Miss Williams since this day, this fateful day for her, October 4, 2019, since that day, every treatment they prescribed for Miss Williams has come from this document as a basis. And it will stay that way forever. It's permanent. Now, yesterday, Dr. Greenberg, who seemed like a nice gentleman, he admitted that he's board certified in neurology, but he's not board certified in neurophysiology. Did y'all hear that? Everybody in the courtroom could hear that. He's not board certified in neurophysiology. What does that mean? That means that he did not get board certified in the specialty of EEGs, reading EEGs. He told you that. Guess who is board certified in both neurology and neurophysiology? Dr. Ross and Dr. Baer. Who the heck's Dr. Ross? Dr. Ross is Dr. Baer's partner, whose name is on this EEG at the top. Dr. Baer testified that his practice is a neurophysiology center because they're both specialists in that. This is what they do. Okay, let's just say this. Let's say somebody still doesn't believe this, okay? Which is perfectly reasonable. Somebody's still not moved by this. Something Dr. Greenberg said makes them think this is still not convincing on permanent injury. Let's talk about it. What was Dr. Greenberg's position on this? I had to read it from his report during his examination yesterday. I kept reading it. Remember, he wrote his report the same day that he saw the patient. He said dictate. He corrected me. He dictated his report the same day he saw the patient. He spent 18 minutes examining her and an hour and 3 minutes, I guess, talking to her. And then he dictated his report. And in that dictation, he says, I don't think this is seizure activity, and if it is, I don't think it's related to the wreck. Does that sound like an expert testimony that's convincing? I don't think this is seizure activity from the report. He only had the report. What does the report say? The left greater than the right, frontotemporal. Remember that word, frontotemporal? Frontotemporal. Front and temporal. Frontotemporal, same area, right? Left greater than right. Wait, left. Left greater than right. Left greater than right. Okay? Left greater than right. This could place the patient at an increased risk of partial or secondary generalized seizure activity. How can an expert, with those words right there, say, I don't think that's seizure? That's all he's got. He doesn't have the film yet. He doesn't have the study yet. All he's got is this report. And he's already concluded that's not seizure activity? How's he doing that? How's he doing that? If somebody on this jury can come up with a reason why a basis that he would have to say this is not seizure activity when all he's got is that. That's all he's got. That's like somebody having an x-ray of a fracture, having nothing else. I'm sorry, not an x-ray. It's like somebody having a report of an x-ray. So you know how the x-ray or film, and I guess you can get doctors that look at a fracture and say, you know what? I don't think there's a fracture there. I'm looking at the film, there's not a fracture there. But we're not looking at the x-ray. We're looking at the report from the x-ray. How can you look at a report from an x-ray and say, it says fracture on the word fractured on there, I don't think there's a fracture? How can you say that? There is no basis that he could give or that you can think of that would explain how somebody can come up with this not being a seizure activity when all you have is this piece of paper. He didn't have the studies yet. He asked for them, but he didn't get them until after his report was done. Common sense versus coincidence. So the seizure disorder is there, and it is permanent. So let's talk about the cognitive stuff. That's a separate injury claim. Is the cognitive stuff there? Is it there? Some people may think that it's not. Let's talk about why it's reasonable and common sense to say it is. Dr. Eastfold testified in this case, right? For the plaintiffs that said that the cognitive issues were permanent. That's what she's a neuropsychologist. Cognitive issues were permanent. Now, every time I say the word cognitive, I want to say your thinking process is messed up. Okay? It's just your thinking process is messed up. Okay? And it's not messed up temporarily. It's messed up permanently. Your brain is now rewired, basically. It's basically what they're saying. How many tests did Dr. Eastfold give after the 3.5 hour meeting with her? How many tests did she give her? Let's see. I think it was like 30 something. Right? Because it's 20, and then this one had subparts, right? Yeah. 2 had all these subparts, right? 32 or something. 32 different tests. And she said the minimum you can give to give any opinion on neuropsych is 2 per domain, which worked out to be, I guess, 6 or 8. Otherwise, you're not really comparing apples to apples. She's the only neuropsych in this case that gave a full battery of tests and did a full neuropsych examination. It was 8 hours and then 3.5 hours of interview time. And I think what's most believable about her is that she didn't come in here and say she's got some devastating, debilitating cognitive issue. She didn't say that. She basically said she has a mild cognitive issue that's caused, that possibly could be caused by a traumatic brain injury. She couldn't say probably, she said possibly. Dr. Baer then takes that and says, more likely than not, probably is related. Any cognitive issues are related to the rape. So that's where Dr. Baer comes in on the cognitive part and gives the permanency on the cognitive part and the causation. But you know what? There may be some jurors, which is perfectly your right, that say, I get the seizure thing, I do not get the cognitive thing, I don't think it's there. You know what? It's fine. Perfectly fine, right? If that's your position, can you still find a permanent injury on the seizures? Absolutely. Absolutely. And vice versa. You may decide collectively there's not enough evidence of seizure permanency, and you may say there is on the cognitive part. And can you find permanency on the cognitive and not on the seizure? Absolutely. Can you find permanency on both? Absolutely. Absolutely. If you find permanency on either, you mark yes to this question. Now, I want to talk a little bit more about proof, because I think it's important to understand why all these papers are back here. Look at all that stuff. Look at all this. It's a binder full of paper. This is ours. This is theirs. Now, I've only referred to 4 pieces of paper. Why is all this relevant? I think a lot of it is. Let me tell you why. What you're looking for as a juror is any indication that something doesn't fit. What does that look like? What does that look like? I'll tell you what it looks like. It don't look like this case, because everything's lined up. Let me tell you what it looks like. You pull out one of these documents from the time period where this wreck happened. Let's say you pull out of their exhibits, you pull out, okay, the counseling records. There's only 6 visits. It's with a licensed mental health counselor. You know what? If I'm trying to poke holes in this case, I'm trying to find every piece of paper I can that says something inconsistent. Inconsistent with what happened. A story that sounds different. I was going too fast and I ran into somebody. I didn't hit my head. I hit my head on the steering wheel. I busted my lip on the console. You're looking for something inconsistent. All these papers, a lot of them, they got more than us. All of them are consistent. Look at the providers. Go to the counselor. Or how about this? Go to a doctor that has nothing to do with the brain. Maybe there'll be something in there that she said that was different. Let's go to the Andrews rehab stuff. Maybe there's something in there that looks different. That's where she told the therapist who's working on her back and neck or some other body part. Again, this is in their stuff too. It all lines up perfectly. Let me show you an example. Let's look at the Andrews records, the rehab records. Thank you. I think there's another page too, right? while she's looking for it. The Andrews records, there you go. Okay, now think about this. You're looking for anything that would give any indication that something's not lining up. She's at a rehab place for back pain, neck pain, right? Maybe there's something in there that just doesn't sound consistent with her story. But when you get this, blow out that paragraph. Blow the paragraph out, please. You're going to have it. You're going to read that. You're going to think to yourself, that's exactly what we heard in this trial. Almost 5 years later. Almost 5 years later. It's exactly what you heard here. And this is not isolated. So then you go to Dr. Rush's record. Dr. Rush is a primary care physician. Same thing. Same thing. Okay. Dr. Baer's record, same thing. Dr. Jager's record, same thing. All these records. If they said something different, trust me, it would be a big deal. Big. Big. It ain't here. It's entirely consistent across the board with every doctor, every therapist, every counselor, every piece of paper in that box that deals with a history from a patient is going to sound like everything you heard in this trial today and from the beginning at the ER. They line up perfectly. Common sense versus coincidence. The other thing that's interesting is, if you're looking through Dr. Rush's records, he actually wrote a letter that's in their stuff, too. It's in West Florida Medical Center Clinic. Oh, yeah, I'm sorry, hold on. West Florida Medical Group. It's Defendant's Exhibit G. It's in ours, too. He wrote a letter that basically describes exactly what's going on. Here it is. What's going on? Pretty early on in this. What does Dr. Rush think? In evidence, their exhibit and ours, the patient suffered a concussion as a result of a motor vehicle accident earlier this month. As a result, she still suffers from post-concussion symptoms to include cognitive dysfunction, poor concentration, headaches, and emotional liability. We didn't hear from Dr. Rush, but Dr. Rush is in the evidence. Just another physician that connects the dots medically. The other thing I think is important when you're looking at the rehab records, because let me tell you why this is important. Rehab, when you go to rehab, some of y'all have done this, but when you go to rehab, you're usually dealing with some pretty, it's usually right after something happens. Right after surgery, right after trauma. And your rehab person, even though they're a physical rehab, they basically become like a counselor. Because you're talking to them about stuff. And a rehab person has to be engaged with you on all levels. In order to evaluate whether or not you're putting forth your physical whatever best, they have to know what condition you're in, and they record it, right? So when you look at the rehab records at Andrews, you're going to see in there that they basically chronicle the mood and the condition that Miss Williams is in every day she's there. And you're going to see in there, I guess you blow up that bottom part, the assessment. Look at this. I mean, this didn't come out through a witness, but we got it in evidence. Look. Dizziness with vomiting episode, vertigo. They're recording all this in real time. Every one of those records from the rehab place talks about how she's exhibiting symptoms of a traumatic brain injury. Every one of them. Every one of them. This was one of the ones where she actually was vomiting. And I don't know if you can tell, but somebody that has a brain injury is not the best historian when it comes to like details and elaborating and communicating like thoroughly. The good news is these records do that. These records show exactly what Miss Williams went through and what she was going through and the kind of symptoms she was having. All of them point to one thing: brain injury. All of them. All of them. Look at Dr. Rush's records. Look at the Andrews records. They all point to brain injury. Every one of them. Everything here. You do not have to just rely on expert testimony in this case. You could win this case as a plaintiff by just what's in evidence. More likely than not, gray area of the evidence, you can just do it based on the box over there. You don't have to, but you got the expert testimony and you got this. You basically got a complete layout from the day this happened to now of what she went through and the kind of symptoms she was having. In that box and in that binder. That is important when I get to talk about damages in a second, because you're going to see what she went through. It sounds a lot worse on paper than it did from her mouth. Put up Plaintiff's 4, Exhibit 4, page 150, which is the ego record. Okay, now this is one of the pieces of paper that we've been talking about a lot. Okay? Now this is an ER visit that occurred the day of the wreck, immediately following the wreck, not 3 weeks later, not a month later, not a week later, immediately after the event. And what does she report? Let's look at see what the records say. By the way, there's some clues in here about how she describes the wreck in every one of these records. So if anybody on the jury is still worried about liability, if you want to use the medical records as further proof as to what happened and how consistent the story is, the records are a pretty good indication of that too. Imagine this. Imagine if Miss Williams had told one doctor that she cut a corner fast, and she told another doctor that she was speeding and her daughter was sick the night before, or she was tired and she wasn't paying attention and she didn't put her blinker on. Imagine she told her therapist that, right? Wouldn't that form a basis for that argument? I think so. I'd argue that. That is not here. This case does not have that. Everybody, every provider, every history, every time she went to see anybody, it's the same exact scenario. Starting with this one. And I think the biggest focus of this one is, plaintiff states she struck her head, but is unsure of loss of consciousness. Okay, you're in the ER and you have a patient that says they struck their head and they're unsure of loss of consciousness. Is it reasonable to assume they had a loss of consciousness or assume they must not have? If somebody tells you they hit their head hard enough to come to the ER and they're not sure whether they lost consciousness or not, what are you going to assume? That they didn't? What's more reasonable? What's common sense tell you? You're going to assume they did. Why is it reasonable to assume that this means they didn't lose consciousness? That is not a reasonable interpretation or implication. That is what they want you to do in this case. They want you, they're experts, and they want you to assume that this means she did not lose consciousness. Because you didn't say, I hit my head and I must have passed out. Or I passed out for a certain number of minutes. Guess they want that? They make it sound like because the doctor says at the end of the visit she's better, that somehow she's well. The ER releases people. That's what they do. Unless you absolutely got to go to the hospital, you're going home. But what did the ER doctor do before they left? What did the ER do for them before they left? He didn't say, call somebody, call anybody, call your primary care doctor. They didn't do that. Nope. What did they do? They made an appointment at the neurologist's office. And they wrote it on the sheet. That's the same Dr. Baer that testified in this case. He's right here on the first day of the rack. The same Dr. Baer. Not getting paid $10,000 a day. The other record that we're going to see again, I guess, for the 50th time, maybe if we're lucky, is the October 21st, 2015 Dr. Jager record. Now, their theory of the case is that this is a psychological problem. 100% psychological, start to finish. And you as a jury can certainly consider that argument. You should. You have an obligation to, right? And the question may be, okay, well, what proof do we have that there was a psychological problem, right? It seems like, I don't like to speak for other lawyers and other parties, but it seems like they're going to argue that here you go. Smoking gun, October 21st, 2015, Dr. Jager, here it is, right? This shows she had a long-standing history of depression and anxiety, and she was a mess before this wreck, and this is just a continuation of a messy psychological problem. And this is the record they're using for that. Now, there are a lot of pieces of papers over here. There's a lot. There are a lot of pieces of papers in this box. There are a lot of pieces of papers in this binder. This piece of paper on the screen is the only piece of paper that they're going to be able to point to for this long-standing history of depression and anxiety. One piece of paper. And what does it say? Well, let me ask this question. If there was a long-standing history of depression and anxiety, would there be more pieces of paper from doctors prior to this that would say something about depression and anxiety? Wouldn't you look for that? It's not in here. But there's plenty of paper in here from prior to the wreck. This is their stuff. A lot of doctor visits. A lot. Because when you're on ADD medication, you can't just get a prescription and see you later next year. That ain't how it works, right? ADD requires you to go see the doctor, I don't know, 3 months, every 3 or 6 months or something? I think 3 months. And so you have to go in and see the doctor, and they have to hand you a prescription. And they have to do an office visit, right? And so every office visit, there's a history, review of symptoms, which, by the way, is a review of your symptoms then existing. Right? You've got that in here. But no long-standing history of depression and anxiety. Nope. So what are they doing? They're trying to get you to believe that because this was a visit with a psychiatrist, and because there's a mention of history of depression and anxiety, that it must have been a long-standing, involved, treated history. That is not there, ladies and gentlemen. What happens when you treat for depression? You get therapy. You get medication. Your medication changes. You go see psychiatrist, because the psychiatrist gives you the medication most of the time if you're really depressed or really anxious, right? There's one prescription for 4 tablets for Ativan so she could fly on her honeymoon from Dr. Rush. That was the extent of the treatment for anxiety before the wreck. If that's a long-standing history of anxiety, then maybe I'm crazy. I don't think the evidence supports that. The evidence supports the fact that there was no long-standing history of either anxiety or depression. Period. And yesterday they went through the review of symptoms on all of Dr. Jager's notes. I'm just going to point you to a couple just so you see what was happening with that. Let's go to okay, I can't even see. Sorry. Let's go to Defendant Exhibit H25. Again, I like to use their exhibits so you understand this is not just things that we have. This is things that they have. Okay? So yesterday we were going, they went through almost all the records where they went through the review of symptoms, you remember, and they said psychiatric and it said present, not present. And they were pointing out that it didn't say she had seizures or whatever. And I think the discussion was, well, that is, review of symptoms is what's happening in the office. In other words, what is the present review of symptoms versus, is this a history, right? So when you look at this, Look at review of symptoms, psychiatric. Not present, anxiety, change in sleep pattern, depression, fearful. All right, all that's not present, right? See that? Neurological, not present. Decreased memory, headaches. Circle this word. Seizure. Can you circle it? Hey, thank you. Okay, now, she was not having a seizure when he was reviewing her symptoms in the office, right? But the suggestion was yesterday that this is a history of recent things. Okay, so let's go to the bottom and see the history. Let's see what he writes in his note. So, no seizures in the review of symptoms, not present. And at the bottom of this note, he's going to record a history, I'm going to show it to you, of recent seizures. He does that a couple times. So, if somebody on the jury was moved yesterday by the fact that it didn't say seizures up there, right? Oh, that's somehow inconsistent. Look right here. She had a little seizure activity and started the medication, right here. If the review of symptoms was a history of recent events, it would have said, yes, present for seizures. It doesn't. And that's in numerous places in Dr. Jager's records. Just in case you thought that might be, somebody in the jury might think that was inconsistent, right? I think we need to address that. So there it is. Don't get confused on the EEGs, right? So there's an EEG in the office that Dr. Baer testified said it takes 20 minutes. That's one EEG. It's like a snapshot EEG, right? Takes 20 minutes, put the thing on your head, 20 minutes, read it. Does it show anything? No. Okay, you're not having anything right now. 20 minutes. There's two of those. 20 minutes EEGs in the records. And then there's only one 72-hour. The one 72-hour one is the one that has the October 2019. It has the seizure activity. Okay? I don't want you to get confused. There's 3 total EEGs. 2 of them are snapshots in the office while you're there, 20 minutes, off and on. You didn't show anything in that 20 minutes. Take it off. The other one, 72 hours. It's like you have an EKG in the office versus an EKG that you wear and take home. Some of us have done that, right? The ability to capture more is the one you take home. That's what they do. I think Dr. Baer and Dr. Greenberg alluded to the fact that you have a constellation of symptoms with a brain injury. Constellation, like constellation of stars, or whatever, it's a bunch of different things that you have. Mood changes, irritability, anxiety, depression, cognitive issues, focus, concentration, headaches. You have like a constellation of issues. So if anybody on the jury is still debating whether there's a brain injury, I promise you the constellation of symptoms that I just went through is all in those medical records. Rehab records, primary care records with Dr. Rush. You don't just have to look at Bear's records. Because if you think about it, you go in to see the neurologist, you see the PA, you're in there for 30 minutes, 20 minutes, whatever. We got more than that in this case. There's other records that support a brain injury if somebody on the jury wants to see more symptoms. They're in there. Dr. Bear said that the ER note by itself establishes a loss of consciousness. Think about that for a second. The treating doctor said the ER note itself establishes a loss of consciousness. By itself. He ain't looking for an unreasonable assumption. He's reasonable. He's not trying to find a $10,000 a day way to say it's not reasonable. The defense argues that there's no objective evidence of a TBI. That's what they said in their opening. There is no objective evidence of a TBI. Did they deliver? No, they did not. They failed. And the reason they failed is that there is plenty of objective evidence of traumatic brain injury, and here is the list in review. Starting with the EEG, because it doesn't deny itself. It's there. You can't do anything about it. You can dress it up. You can put trees around it, put some shrubs, some nice bushes, try to camouflage it. It ain't going anywhere. Okay? Their expert couldn't even dress it up. All he could say is, I don't think it's seizure activity, even though it's in the record. And if it is, I don't think it's related. That's what this is. No mark on her head. They talk about this a lot. No bruise, no laceration, no blood. How can you have a brain injury without lacerations, blood, right? What did Dr. Bear say? Dr. Bear said the most common injury is soccer. Soccer. When they head the ball, it leaves no mark. None. Think about that. A soccer ball. A soccer ball is what Dr. Bear says is the most common injury. He brought it up. Wasn't even a question. Soccer ball. No evidence of impact to her head. Huh? No evidence of impact to her head. I wrote this down. It's in their opening. No evidence of impact to her head. Where is there not evidence of impact to her head? From the scene. Even the defendants admitted. The defendants even pointed to the place in her head that she said she was hurting. What do you need? Guess what Dr. What was his name? Greenberg said. Did you hear him yesterday? I wrote it down. I couldn't believe he said it. I would need a video of the accident. Wait a minute. You would need a video of the accident to testify that she hit her head with this evidence? But he's the same guy that says, to prove she has a seizure, you got to have a video of that too. This is that guy. Their seizure guy says, in order for him to testify 100%, because he's a 100% doctor, evidently. We're not in a 100% situation right now, but he's 100. he has to diagnose things at 100%. God forbid there ever be a day where doctors have to do that. But this guy yesterday said he has to be at 100%. So it's got to be captured on video. Otherwise, it's not there. Despite the EEG. No impact with her head. That's what they said. And then they say, no permanent injury. That's their other argument. Make sure they address, if you're listening to them, make sure they address which injury he's talking about, right? Because they might want to combine the two. Think about this. Let's say I have two arguments, and they're equal, and they're distinct, and they're two injury claims that are separate. They travel on separate tracks. If one might be a little stronger than the other, then maybe I'm going to try to combine it. And if I'm defending the case, maybe I'll try to combine the defenses. Be careful when he's talking about cognitive damages versus when he's talking about seizures. They're two distinct injury claims. Both of them travel independent of each other in this case. Either one can be permanent. Or both. Dr. Baer testified there's a permanent injury on cognition and seizure. Okay? Eastfold testified there's a permanent injury on cognition. And I guess defendant had Dr. Greenberg, who said there was no permanent injury for the seizure. And it should have cleared up within a year, and he didn't think she had a TBI. Now, this is the doctor that also had to be reminded that there was evidence that she hit her head in the ER. Because remember, after a year being involved in the case, he came to a deposition and he said she didn't strike her head. And he had his deposition, he was like, oh, I was wrong about that. She did strike her head. So if you imagine this, you're an expert, you're charging money per hour. I can't remember what he said his hourly rate was, but it sounded pretty impressive. And maybe he's worth it, I don't know. But he's charging them money to prepare for his deposition. Then he comes into the deposition, which he's charging money for that too, and he doesn't know for sure whether this brain injury person that he's testifying against hit her head. That is what he's testified to. All right, so you're the brain specialist. You've been hired to be the brain specialist for a brain injury case, and you're at the deposition stage, which means you've gone through the exam, you've read their medical records, you've charged however much money it was before the deposition, I think it was $11,000, and he gets to the deposition and he doesn't know whether she hit her head. How much time did he spend on this case? Seems like a basic fact that the brain expert would need to know, did she hit her head or not, before he testifies, right? He admitted, to his credit, he admitted that medicine isn't practiced at 100%, typically. Imagine that. Imagine if every doctor had to be 100% certain that you had X before they treated you. Imagine. No, they don't operate that way. They go on evidence. What's more likely than not? Right? But he wants you to apply a 100% rule to this case. He wants video of the wreck. He wants video of the stroke, of the seizures, before he'll say it. It's not what the law requires. It's more likely than not video evidence at 100%. The other argument the defendants make, and I've touched on this already, but I'll be brief, is everything is related to pre-existing anxiety and depression. And they're going to throw Dr. Jager's note from October And they're gonna say, look, she got a history of this, she said it was a history back a long time ago. There is no history. There's just not. There's a history of ADHD. I promise you of that. It's all in that. Everywhere in that box in the binder, there is a long, long history of ADHD. There is not a long history of anything like depression, and the only anxiety treatment she got were those 4 pills for her honeymoon flight. 4. Not 4 prescriptions, 4 pills. But they want you to believe that as a coincidence, this wreck happened. And suddenly, these long-standing conditions that she didn't have morphed into some kind of damage to her brain. That's their argument. As a coincidence, the wreck just is a coincidence. They say no memory issue. Again, all you got to do is look at these records. You ain't got to believe anything I say, they say, the witnesses say. You ain't got to do it. Look at their box. You don't even have to look at my binder. Just look. It says it all in there. I'm having trouble remembering this. My memory's off. It's all in there. And if you want to just look at one set of records to get you the best picture of what she was going through, look at the rehab records from Andrews. That therapist does a phenomenal job of chronicling everything that's going on with her. Even if it didn't relate to the therapy that she was employing. Because she was doing her job. But look at it, it's right there. It's their exhibit and mine. They say there's no altered thinking. Here's what I'm going to give you on that. Again, in evidence. Okay? So, Baptist, everybody knows Baptist Hospital. Everybody knows West Florida Hospital, right? They're corporations. They have set protocols for employee review process, right? They have forms that have to be used every year to evaluate the performance of employees. They have to be scored. The scores have to be calculated. That calculation goes into a formula for them. We have that for like 10 years before this. I think her first form that she filled out at Baptist was 2010. 2010. So we have from 2010 until she basically was forced to leave Baptist. And then we have Medical Center Clinic for a year and a half, 2 years. And what do we have from them? You're going to see her reviews. And they actually say in there what her thinking is like. Somebody over her who's charged with the responsibility of critiquing her is evaluating her mental processes day in and day out at her job. And then they have to score it. Is it a coincidence that those scores hit the floor after this wreck? Common sense would tell you that's not a coincidence, right? You're going to have, that's the Medical Center Clinic one. Go to the Baptist ones. The The Baptist ones are broken down while she's looking for that. They're questionnaires, and I think they say meets expectations, exceeds expectations. I can't remember what the other category is. But anyway, she is either meeting or above expectations on nearly everything she does. Then they give them a score. All this is in evidence. 17, is that right? Okay. And they chronicle all the way up. You don't need to look at all of them unless you want to. But I was curious. Okay, let's look right before the wreck happened, right? What kind of performance is she having before this wreck happens? So look at 17, 18. And then look at 20, 21, and watch what happens. It's not her talking. It's somebody that's supervising her, that's watching her, that works with her, that sees her every day. The thing that's important about the long history, though, is she gets promoted and she has good reviews every year from 2010 to present, to 2019. That's a long time. It's almost a decade. Common sense versus coincidence. So that gets you on the verdict form to number 5. It's going to be important that we discuss this in some detail because each one of the words in this paragraph is a separate type of damage. So, pain and suffering is a separate category of damage. Disability is a category of damage. Physical impairment is a category of damage. Disfigurement, of course, is a category of damage that we don't have here, right? Because it's not disfigured. Mental anguish, inconvenience, those are separate categories of damage. Aggravation of a prior issue, loss of the capacity for the enjoyment of life. Those are all separate categories of damages. And the law is that you should consider those separate, even though they're the same paragraph, same sentence. They're separate items of damage, each one of those, and you have to think about them separately. What evidence do we have of pain and suffering? What evidence do you have of mental anguish? What evidence do you have of the loss of the capacity to enjoy life in the past and in the future? Inconvenience. You heard the word inconvenience. How inconvenient is it for Miss Williams to have to go to all these doctor visits and to have to not drive for over a year? Have to have somebody rely on somebody else for transportation for over a year. Inconvenience. Mental anguish. It's pretty much what's the emotional toll on you because of all of this, right? And then loss of the capacity to enjoy life. How has your life trajectory been changed? The capacity you had to enjoy life before the wreck versus the capacity you have to enjoy life after the wreck. Has that trajectory been narrowed at all? If it's a rocket and it was going straight up before the wreck, has it been diverted in any way? Down? Is your trajectory going to be a little more towards the earth than straight up towards the moon? What is it like to live knowing that if you're walking across a parking lot on your medication, you could just fall out on your face? What is that like? Remember what Dr. Bear said about this fall in 2023. He wanted to find a reason other than seizure. He was like, let's do all this heart stuff. Let's figure out. And did you hear what he said? He ruled it out. They did all the heart stuff. There was no heart issues. And then he said something important. He said the other thing that was important is that she had no wounds on her arms. And he says when you have the heart type failure or heart syncope, you get some pre-syncope symptoms, I guess. You sort of know the room's spinning or you're lightheaded. And so you have some time to like move your arms out or brace yourself or grab something or go to your knees. Nothing. There were no marks anywhere except her face and her knee. She went like this. Imagine living with the fear that you could go from this position to this position without any warning for the rest of your life. She's got 39 years of life expectancy. Now, what they hope and what the treatment is there for is that they reach a point of the medication where you don't have breakthrough seizures. Or you have, if you have a breakthrough seizure, you're not in someplace dangerous. And they can adjust your medication, and then you're good for another period of years. That's what they do. They try to get the medication to a level, and you'll see in the records, every time she has an issue, they're cranking that medicine up to the next level. That's what they do. So she started off with the Trokendi. Now she's with Lamictal. But you'll see, whether it's Trokendi or Lamictal, it's being increased as these breakthrough seizures happen. On the mental anguish part of this, you got to think about what she said, okay? First of all, she strikes me as somebody that has a close relationship with her family, which is good. She also strikes me as somebody that wants to impress her parents. Number one, she's trying to. Every kid wants to impress their parents. Everybody wants to impress their parents. They want their parents to be proud of them. They want their kids to be proud of them. What was her number one thing that she said that she got self-confidence and self-fulfillment out of? Work. Her career. Not just a job. Not just a job. Her career. Now she has a job. She's got an entry at home. And she's thankful she's got a job, right? And she wasn't woe is me about it, but she had a career with a plan, goals. Vice president of whatever operations, whatever she said, right? Gone. For now. That is where she got her enjoyment of life and her daughter. That and her daughter were the two things that gave her joy. Her daughter's still there, right? That relationship has been affected, but her job, her career was taken from her. Gone, lost. Maybe not forever. But for purposes of this case, it's gone. So it comes down to trying to figure out what to put in these blanks for damages, right? Because there's really, since there's no claim for wages and no claim for medical bills, there's just one section for money damages on this verdict. It's almost been 5 years since the wreck happened, so that's the past, right? And the future's 39 years, basically. And I like to think in damages in terms of how a person experiences damages. We don't really experience damages when we're asleep. Because we're asleep. Unless you have something wrong with you where you can't sleep, right? When you're asleep, you're asleep. You're not aware. You might have a bad dream, you might have a good dream. I don't know, but you're not going to have mental anguish while you're sleeping. So I like to include about 18 hours a day when you think about damages. I think it in terms of hours, like awake hours. So if you think in terms of awake hours, I'm not the best math person, but, and you guys probably should check my figures. You're welcome to. 39 years, I believe, is 256,230 hours. Awake. Where she has to experience pain, suffering, disability, impairment, anguish, inconvenience, aggravation of a prior issue, loss of the capacity to enjoy life. So that's the future, right? The future is 256,230 hours awake. And if you thought $10 an hour, or I'm sorry, yeah, $10 an hour is enough for that, that'd be like $2 million, $2.5 million for future damages. If you thought $5 is enough to deal with these problems every hour of your life for the rest of your life, maybe you do, then it would be $1.281150 million. You may think $20 an hour. I don't know. You may think 50. You may think 1. I don't know. But this is the way that if I was on a jury and all I was told is what's fair and just under the circumstances is really what you got, that's what the instruction says. When you experience damages like this, you're experiencing them as a human being that's awake. And you've got future and you've got past. So the past is about 1,825 days, which is 32,850 hours. 32,850 hours since the wreck, approximately. I didn't do it to the day, but approximately. If you give $10 a day for that, that's $328,500, $328,500. If you give more than that, then there's obviously more than that. I would suggest that when you're thinking about past damages, things are worse at the beginning of something, right? The pain and suffering, the mental anguish, the inconvenience, all of that stuff is worse at the beginning of something in the past. As far as the amount of it, right? You get to a new normal, it's forever, but you get to a new normal where I got medication for the rest of my life for seizures, and I'm trying to do the best job I can do. And I'm just dealing with this one. It's a permanent situation, but I'm in a new normal. But before you get to that new normal, you got to go through a lot to get to that stage, right? So maybe $10 a day for the past is not enough, but y'all will discuss that. So the way this process works is from here is that I sit down, and then the defense comes and they argue their argument. And then I get to stand back up because we're the plaintiff and we have the burden of proof, or great weight of the evidence. I get to go again, and I get to address what he addresses to you. So at this point, I'm going to sit down, and the defense is going to do their closing argument. I thank you for your attention.
Thank you, Mr. Zarzaur.
Thank you.
Ladies and gentlemen, this is a good time for us to take a recess, let everyone stretch, use the restroom. Please still need to order your lunches. We may mark that, I'm not sure. But if not, take care of that. So we'll anticipate about a 10-minute recess, and then we'll have the defense close. Don't talk.
misspoke in my first closing. I said Dr. Rush did not testify. He did testify, Dr. Rush. He testified by video. I just forgot he was by video. I apologize for that. Can you put up the drawing, intake notes drawing? Got it? Intake notes drawing, did I? Correct. Sorry. Yes. This is, I think, Defendant's Exhibit 1. Thing to remember about this, Ms. Williams says she didn't draw this. She didn't put any of the marks on this page. None of it. This is not her doing. And when I showed it to her, she said that the impact would have been out here, closer to the turn line. Just remember that. Okay, so they started with a liability argument. They are arguing that they're not at fault for this wreck. Think about that for a second.
And I would object to misstating the evidence. I just showed on the verdict that the sparks is partially allowed, so that misstates the evidence.
They are arguing that a majority of this fault in this wreck is Miss Williams' fault. A majority. Where their client has the stop sign. And our client has the right of way. They're saying our client is a majority at fault. I can't help but look at that argument and then think about the other arguments they're making. They say liability is disputed. But what is it disputed by? I think they say, well, your client said she was sorry. Therefore, she must be responsible for the wreck. And I don't know if y'all noticed, but when Miss Williams was up there, and you could tell it wasn't an intentional thing because it was almost like it was coming out before she even think. She apologized probably 30 times in her testimony. I'm sorry. I was like, I'm on the wrong page, or I'm not reading the right thing, or I'm not looking at the right thing. She was just constantly apologizing. In front of you, she did that. The defendant admits that she saw Miss Williams' car before this happened. So you as a driver at a stop sign and you see another car, you have the obligation to see what that car is doing before you make a turn in front of it. This ain't rocket science. Those cars have the right of way. Those cars that you're seeing have the right of way. You do not. You're stopped. By law, you're stopped. You can't so much as move until you've determined that it's safe to move. The impact was minor, but then he said it was 180 degrees of a spin after the impact and the damage to the car, and it's a minor impact. And the inside of the door frame is all jumbled, not to mention the door is mangled. And who's trying to get into traffic, by the way? Who's trying to weave their way into traffic? Who has more of an incentive to go fast and get somewhere into the traffic pattern? The person trying to get into traffic, or the person just turning left into a shopping area? That's common sense. That's why she spun. That's why there's damage to the inside of the door jamb. The truck was moving. "66% Miss Williams' fault. And their client was at a stop sign, and our client had the right of way. That was their argument on liability. Then they say no traumatic brain injury. So let's talk about that for a second, because there's some discussion about traumatic brain injury and seizure activity. I don't want to get those confused. Okay? He says alleged head injury. More likely than not, when you review this case, all the evidence, the admission from the defendants that she was holding her head at the scene, all the treatment records, the consistent story she gave all the doctors, the therapists, the physical therapists, the counselors. More likely than not, do we think there was a head injury? He says there's no break in the window, therefore there's no head injury. There's no immediate pain, therefore there's no head injury. No expert said that. No expert said if you don't have immediate pain, you don't have a head injury. How many times can you imagine a person being injured in a situation and they don't feel immediate pain, but within an hour or so, things start hurting? A couple days, it gets even worse. Seems like a reasonable thing to me. Put the 72-hour EEG up, please. Now, when they were talking about, notice I didn't mention the 20-minute EEGs when I was talking to y'all initially. I purposely did not bring those up because I didn't want to get confused with those. I didn't bring it up at all. He brought up the first EEG, the 20-minute one, in the office. It was abnormal, but the doctor said it was not significant. So I didn't even talk about it. I focused on the one that the doctor said was abnormal and for which they freaked out that she was driving, she even drove to the office about. And they revoked her driver's license and put her on seizure medication for the rest of her life. That's the one I was focusing y'all on. And on this one, which is not the first one, they're different. He goes to this word suspicious for epileptic type activity. Okay? We didn't read the rest of it. This could place the patient at increased future risk for partial and or secondary seizure activity. You rarely capture seizures, you capture the things that cause seizures in your brain, the activity. This is why the board-certified neurologist, neurophysiologist, revoked her driving privileges for 6 months and told her she's going to have to go on anti-seizure medication for the rest of her life. This is it. There's nothing suspicious about that report. Then he made this statement. In this context, there's no objective evidence of a TBI. Now wait a minute. That's not the same thing as objective evidence of a seizure, right? That's not what he said. He said objective evidence of a TBI. We talked about that. What would be objective evidence of a TBI? Because remember, the doctors all told you it doesn't show up on a CT scan or an MRI. So you ain't going to get it there. And you don't necessarily have to have a mark on your head because you can get it from a soccer ball that don't leave, according to Dr. Barrett, doesn't leave marks. So what's going to be objective evidence of a TBI? What? Either a video of the event, maybe? Because unless you have something worse than a mild TBI, which doesn't bleed in your brain, the doctors told you it ain't going to show up on any studies. So don't get confused when he says to you there's no objective evidence of a TBI. So, there's all kinds of evidence of a TBI, and there is no such thing as an objective evidence of a TBI unless it's something more than a mild TBI. That's what the experts told us. What they can't say to you is that there's no objective evidence of seizures. Now, Dr. Greenberg said there wasn't. But Dr. Baer and all the evidence in this case, and starting with this EEG, that's objective evidence of seizures activity. Psychological issues do not cause you to have EEG activity indicating seizures or the potential for seizures. They called it objective evidence. This is objective evidence. Is it objective evidence of a TBI? No. A traumatic brain injury. You have to prove that with evidence. Because this doesn't tell you how it got there. This tells you what you got. If you have a picture of a fractured bone in your arm, it doesn't tell you how you got the fracture. You got were they playing baseball? Were they in a car? Did they fall? You got to have some facts. You don't take the x-ray from a fracture and say, I can't tell you whether they had they had a traumatic fall or not from the x-ray? Well, of course you can. They talk about the CNS testing and the computer testing in the office, Dr. Baer's office. Remember, that relates to the cognitive issue. Has nothing to do with the seizures. Other than somebody with seizure issues probably is not in the best position to be taking a cognitive test on a computer. It's flashing. Ms. Williams told you why that computer test was just not something she could deal with. It's too much. And if you look and see how she's complaining about lights, sensitivity to light, sensitivity to computers, she's not just telling you that, she told the therapist that. She told the doctors that in her medical records. What did Dr. Baer do when he realized that she couldn't get through that computer test? He ordered another one, and then when she couldn't do that one, he ordered a full, regular, 34-question neuropsych test. The old-fashioned way, on paper. They make this argument that why would you apply for a job if you know you have a devastating brain injury? This is like the same, like within a month or two of this happening. If you're in her position, you're a career, think about her in her career, trying to keep her job, trying to maintain, and you realize you got this injury, you have no idea what impact it's going to have on your life yet. No clue. You're scared to death. You're telling every doctor, therapist, counselor you see, you're scared to death. You don't know what the future's going to hold. You popped off at your boss because you're irritable. You'll see that in the records too. And I guess they expect her to sit at home and not do anything? Just hope for the best? How's it a bad thing she was trying to work? Trying to continue working. How's that bad? Does that make her crazy? Psychotic? Sounds the opposite to me. This discussion about these seizures, was this a seizure? Was that a seizure? Why are they not the same? They're getting worse. You heard that. They're worse. Not better, they're worse. Dr. Baer talked about what he did to rule out other causes of the seizure. They did the cardio testing. They did the blood analysis for any autoimmune disorder. They checked thyroid limits. They did a CT and an MRI of the brain to see if there's structural abnormalities deep within the brain that would cause it. These signals on the EEG. They didn't find any of that. And so then the question was about the parking lot, and within a reasonable degree of medical probability, was it your opinion this was a seizure? I would say, with a normal cardiac workup, I would say yes. I would say that was more a seizure. And they just told you that he testified differently than that. There's also some dispute. He read another portion of the deposition about whether she lost consciousness that day. And I'm going to read from that same trial testimony. Did she seem to fit within the definition? And we had talked about consciousness. She seemed to have that complaint in the ER. She said to me, and I guess her mother who picked her up witnessed it or whatever, and she did. He accepted the fact that she thought she may have lost consciousness as losing consciousness. He accepted his patient's report in the ER. In response, they basically say, here's exactly what they say. There's no evidence that she's a liar. But all this is in her head. And it's 100% the result of her bad marriage and pre-existing depression and anxiety. He then said that Dr. Jager said in his October 2015 note that he was diagnosed her with depression, anxiety, and attention deficit disorder. Look at that. I'm not going to pull that note up again because we put it up 100 times, but the note does not say that. The assessment says attention deficit disorder, anxiety. There is no diagnosis of depression. There's no long history of anxiety or depression before the wreck. It's not there. It's just not there. If it was, you'd see 1,000 records from other doctors. You'd already seen it. They're not there. But that's their theory of the case. Long history of psychological problems, long history of depression, long history of anxiety. That must be the cause of everything. Dr. Baer testified that those psychological issues do not cause this kind of seizure thing. They just don't. So these other doctors came up with this somatoform or whatever they call it, whatever that is. There's no evidence. The more likely than not approach, the common sense approach, when you draw a straight line from the day this happened to now, is she suffered a head injury, it caused this damage, which resulted in the seizure activity, which has caused cognitive problems. It's that simple. We talked about they talked about bias. I want to read you that instruction. I think I read it in jury selection. Part of the jury instruction says, like I said, in jury selection, you only can decide this case on the law that's in this package and the facts of this case. Nothing from the outside can come into the deliberations. And remember, when I was talking to you, you can't feel sorry for one side or the other. That can't be the driving force of your decision, right? You have to only decide on the facts and the law. Bias or sympathy for either side. That's when I said that Bill Gates and homeless person. You can't consider that stuff. It's outside the evidence. You have to focus on what's in evidence and what the jury instruction says. They brought up Ms. Williams' marriage issues at the scene. That there was a phone call that basically, I think, basically set everything off. There's one phone call with her husband at the scene that has set all this off. Like, I guess that was the bomb, the fuse that lit everything. And boom, from that phone call with her husband in a couple minutes, this whole thing is caused by that. She was dealing with Mr. Williams well before this wreck. And managing so well she wasn't diagnosed with anything that needed treatment other than ADHD before this wreck. And she was excelling at work. There's also a portion of Dr. Baer's testimony where this discussion about whether stress can cause a seizure. You'll remember it collectively yourself, but Dr. Baer testified that stress doesn't cause seizures either. So you're back there. This is the day, this is the only day that both these parties have for you to decide this case. And it affects both of them for the rest of their lives. So it's a big deal. And there ain't no coming back. So we know, given the attention you've paid to us this week, we know you're going to pay attention to these deliberations and pay close attention. And again, I just want to thank you for being so attentive. Thank you.